An average of 6 times as many people are shot as in other mass shootings.
They should be respected.
Reclaiming my time. So, Mr. Chairman, I'd like 40 seconds
I've seen
back on
my
the clock.
constituents die in battle.
Irresponsible to allow people without specialized training to possess these weapons.
Piece of legislation and voting on whether this nation is going to be all in on a new nuclear arms race.
Assault weapons are designed to kill as many people as possible as quickly.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
Illinois attack arm ban. In a recent decision, the Illinois Supreme Court upheld the state's ban on so-called attack arms and large-capacity mags. The legal challenge, brought by Illinois State Rep. Dan Calkins, had argued that the ban violated equal protection and special legislation clauses of the state constitution. Illinois enacted a ban on attack arms and large-capacity mags, which came into effect earlier in the year. The legal challenges against this ban unfolded in both federal and state courts. The decision from Illinois Supreme Court, in particular, has garnered attention for its impact on the state's arm control landscape. The legal challenge was based on the assertion that the attack arm ban violated the equal protection and special legislation clauses of the Illinois State Constitution. Representative Dan Calkins, the plaintiff, contended that the ban treated arm owners unfairly and lacked a rational basis. The argument centered on the idea that the restrictions disproportionately targeted law-abiding citizens, infringing on their constitutional rights without a justifiable cause. Justice Elizabeth Rochford, delivering the opinion, sided with the state, rejecting the lower court's decision that found the ban unconstitutional. The court argued that the ban did not violate the equal protection and special legislation clauses of the state constitution. Justice Rochford's opinion focused specifically on the argument that the legislation should be considered null and void because it allegedly violated the state's 3-reading rule for legislation. The timing of the Illinois Supreme Court's decision coincided with a visit by Vice President Kamala Harris to Chicago, where she addressed Everytown activists. The political contacts, along with Justice Rochford's history of association with anti-armed groups like Moms Demand Action, has led some observers to question the impartiality of the decision. The Illinois State Rifle Association highlighted this coincidence, suggesting a potential influence on the court's ruling. Notably, the court's decision did not delve into Second Amendment considerations. The opinion stated that the plaintiffs had waived any independent claim that the restrictions impermissibly infringed the Second Amendment. This omission leaves the broader constitutional question surrounding the ban unaddressed, focusing solely on state constitutional grounds. While the court's decision is a setback for those challenging the attack arm ban, it is essential to recognize that the ruling is limited in scope. The court did not provide a comprehensive analysis of Second Amendment issues, leaving room for future legal challenges that specifically address the constitutionality of the ban concerning arm ownership rights. The Illinois Supreme Court's decision to uphold the state's attack arm ban marks a significant development in the ongoing legal battles over arm control. The court's focus on state constitutional grounds, rather than delving into Second Amendment considerations, leaves room for continued legal challenges on federal constitutional grounds. The decision, taking place in a politically charged context, underscores the complexity of the intersection between legal interpretation and public policy on armed rights.
An average of 6 times as many people are shot as in other mass shootings.
They should be respected.
Reclaiming my time. So, Mr. Chairman, I'd like 40 seconds
I've seen
back on
my
the clock.
constituents die in battle.
Irresponsible to allow people without specialized training to possess these weapons.
Illinois court upholds. The recent decision by the Illinois Supreme Court regarding the legal challenges to the state's ban on so-called attack arms and large-capacity mags has stirred significant debate and concerns among arm owners. In this case, the court upheld the ban, rejecting arguments that it violated the equal protection and special legislation clauses of the state constitution. Justice Elizabeth Rochford, writing for the majority, emphasized that the plaintiffs were not similarly situated to trained professionals and, therefore, the Equal Protection Clause was not violated. She argued that those who possessed restricted items were treated similarly to grandfathered individuals, while those who did not possess such items were dissimilar to the grandfathered individuals with a reliance interest in retaining them. One critical aspect of the ruling focused on the three-reading rule for legislation. Rochford contended that the plaintiffs' failure to cross-appeal from the denial of relief under this rule barred them from renewing their claim. This notion was disputed in two dissents to the majority opinion, including one from Justice Holder White. The majority's argument was based on the Circuit Court's favorable ruling on certain sections of the Protect Illinois Communities Act, upholding some and invalidating others. They asserted that the three readings rule issue was not properly before the court, because plaintiffs should have cross-appealed from the denial of relief on that claim. However, the dissenting opinion argued that the plaintiffs were properly before the court, and the three readings issue should be considered in light of the invalidated sections of the Act. The decision, while specific to Illinois, reflects broader debate surrounding arm control measures, constitutional interpretation, and the rights of arm owners. Advocates for arm rights often raise concerns about equal protection under the law and argue that restrictions on certain arms infringe upon the Second Amendment. In this case, the Illinois Supreme Court's focus on the Equal Protection Clause as opposed to the Second Amendment suggests a deliberate choice in legal arguments. The court's decision also sheds light on the procedural complexities involved in challenging legislative actions. The debate over the three readings rule highlights the intricate nature of legal challenges, where nuances in procedure and constitutional interpretation can significantly impact the outcome. The dissenting opinion, particularly from Justice Holder White, underscores the importance of considering procedural requirements and their impact on the validity of legislative acts. The argument that a finding of a three readings rule violation on certain sections of the Act should apply to the entire Act raises questions about the interconnected nature of legislative measures and their legal scrutiny. As the legal landscape surrounding arm control continues to evolve, this case adds another chapter to the ongoing dialogue about the balance between public safety, individual rights, and constitutional principles. It remains to be seen how similar legal challenges in other states will unfold and whether the courts will consistently grapple with the intricate legal and constitutional questions posed by arm control measures.
Piece of legislation and voting on whether this nation is going to be all in on a new nuclear arms race.
Assault weapons are designed to kill as many people as possible, as quickly.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
SCOTUS and attack arms. The recent Illinois Supreme Court decision on the state's ban on so-called attack arms and large-capacity mags has significant implications for the ongoing legal challenges against similar bans in other states. The decision, delivered by Justice Elizabeth Rochford, upheld the ban and rejected claims that it violated the equal protection and special legislation clauses of the state constitution. While the ruling focused on state constitutional issues, it did not directly address Second Amendment questions surrounding the ban. The case was brought by Illinois State Representative Dan Calkins, and the court's decision aligns with the state's Democratic-controlled stance on arm control. The timing of the decision, coinciding with Kamala Harris's visit to Chicago and her speech to Everytown activists, suggests a political influence on the outcome. The Illinois State Rifle Association pointed out this alignment, indicating a potential bias in favor of arm control measures. Justice Rochford argued that the Equal Protection Clause was not violated, stating that plaintiffs were not similarly situated to trained professionals and emphasizing the reliance interest of grandfathered individuals. The decision did not delve into the Second Amendment implications, as the plaintiffs had waived any independent claim related to the Second Amendment in the Circuit Court. One notable aspect is the court's disregard for the 3-reading rule violation claims, asserting that the plaintiff's failure to cross-appeal barred them from renewing the claim. However, dissenting opinions, including one from Justice Holder White, contested this interpretation, arguing that the plaintiffs had raised the issue appropriately and that the court could consider the 3 readings issue. The Illinois State Rifle Association indicated that the decision might prompt the plaintiffs to seek relief in federal courts. Representative Calkins could now take his appeal directly to the U.S. Supreme Court, bypassing lower federal courts. This case could become a pivotal challenge to attack arms bans, and the Supreme Court's potential review could offer clarity on the constitutionality of such bans. While the Illinois Supreme Court decision focused on state constitutional grounds, the federal courts could provide a platform to address broader Second Amendment concerns. The U.S. Supreme Court has several options, including waiting for decisions in other circuit courts, such as the Fourth Circuit's ruling on Bianchi v. Brown, or considering Calkins' case once certiorari is requested. The possibility of combining multiple cases may also arise based on the timing of circuit court decisions. In essence, the Illinois Supreme Court decision underscores the ongoing legal battle surrounding attack arms bans, and its potential impact on federal courts could shape the trajectory of Second Amendment jurisprudence. Regardless of the state-level ruling, the ultimate determination of whether the government can ban commonly owned arms rests with the U.S. Supreme Court, which holds the authority to provide a final word on the constitutionality of such bans.
It simply prevents future sales of assault rifles.
This is a lever action. Under this bill, lever actions apparently are okay.
Bill will allow current law-abiding gun owners to keep all of their guns.
Conflicting arms regulation. The proposed arm control laws in New Mexico, particularly those anticipated from Governor Michelle Lujan Grisham's administration in 2024, have sparked concerns and debates among the public. This follows earlier attempts, met with judicial opposition, to suspend the right to concealed and open carry through a public health executive order. The forthcoming arm control measures include efforts to ban so-called attack arms, implement a 14-day waiting period for arm purchases, hold arm manufacturers liable for third-party criminal conduct by piercing the Protection of Lawful Commerce in Arms Act, PLCAA, and introduce red flag laws. Additionally, there appears to be a push for the enactment of the Gas-Operated Semi-Auto Arms Exclusion Act, colloquially known as the Ghost Safe Act, at the state level. The proposed legislation has raised concerns among citizens who fear that these regulations may impede their ability to exercise their Second Amendment right to keep and bear arms. The Second Amendment, which guarantees the right to bear arms, is a fundamental aspect of American constitutional rights. As with any discussions on arm control, opinions on the matter are strongly divided, and the enactment of such laws is likely to trigger more disputes and legal challenges across the United States. One of the primary components of the proposed law is the ban on attack arms, a term often subject to interpretation. Advocates argue that restricting access to these arms is essential for public safety, especially considering their involvement in high-profile mass shootings. On the other hand, opponents contend that such bans infringe upon individual rights and fail to address the root causes of armed violence. The introduction of a 14-day waiting period for arm purchases is aimed at implementing a cooling-off period to prevent impulsive acts of violence. Supporters believe this measure can help reduce incidents of domestic violence and suicides. However, critics argue that it imposes unnecessary delays on law-abiding citizens seeking to exercise their right to self-defense. The attempt to hold arm manufacturers accountable for third-party criminal conduct by piercing the PLCAA is a significant departure from current legal protections. The PLCAA shields arm manufacturers from liability for the criminal misuse of their products. Critics argue that this proposed change could open the floodgates to lawsuits and negatively impact the arms industry. Red flag laws. which allow the temporary removal of arms from individuals deemed a risk to themselves or others, have gained traction in various states. Proponents assert that these laws can prevent potential tragedies by identifying and intervening with individuals showing signs of danger. However, opponents express concerns about due process and the potential for misuse or abuse of these measures. The Gas-Operated Semi-Auto Arms Exclusion Act, or Ghost Safe Act, is another contentious element. This proposed legislation, targeting certain arms components, reflects the ongoing debate over regulating accessories and modifications that could enhance an arm's lethality. As these proposed arm control measures navigate the legislative process, their fate will be determined by a combination of legislative decisions, court rulings, and public opinion. The potential impact on individual rights, public safety, and the arms industry will be closely scrutinized, and the ongoing debate over the balance between arm control and Second Amendment rights will likely persist.
The previous ban on assault weapons. This has nothing to do with the Second Amendment.
And I support their ability to exercise their Second Amendment rights.
The most popular handgun in the United States that was purchased is a Glock 19.
Ghost Safe Act. New Mexico Senator Andrea Romero is set to introduce a state-level bill reminiscent of the federal Ghost Safe Act, reflecting a growing trend among states to adopt laws mirroring proposed federal bans on arms and mags. The state measure is expected to closely align with the federal version, aiming to regulate and restrict certain arms and components. The Ghost Safe Act primarily focuses on arms using gas or gas-powered semi-automatic mechanisms, intending to curb their import, sale, production, transfer, reception, or ownership. Under the proposed legislation, a comprehensive list of gas-operated semi-auto arms, including those modified to function similarly to conventional rifles, will be compiled. This targeted approach signifies an attempt to address specific arms perceived as potential threats to domestic and international trade. By outright forbidding certain arms and their components, the bill seeks to exert control over items that might be assembled to create an arm with functionalities akin to banned ones. A notable aspect of the proposed law is its impact on arm components, especially those involved in the assembly of arms. The bill intends to regulate a combination of components that could transform a legal arm into one with features resembling banned arms. This includes scrutinizing parts like AR-15 uppers, raising questions about the ownership and sale of these components in the future. The uncertainty surrounding the fate of such components has led to concerns with the arm community, as these regulations could potentially reshape the landscape of arm ownership in New Mexico. The backers of the bill emphasize that its primary focus is on prohibiting certain arms in the future. However, they have included a loophole that allows individuals to retain ownership of arms they currently possess. This approach attempts to balance the restriction of future acquisitions while allowing individuals to maintain possession of arms acquired before the implementation of the law. Nevertheless, such regulatory frameworks often introduce registration requirements, a common practice in other jurisdictions with stringent arm control measures. The Ghost Safe Act extends its impact beyond arms to include regulations on mags.
Many of my constituents are responsible, law-abiding gun owners.
In the Heller case, the Supreme Court made clear that the Second Amendment protects firearms in common use, and they're coming for your firearms. 6 weeks ago, it was the red flag law.
Effects of suggested arm control. According to the measure that is now being presented, if the provision is approved, it would be illegal to possess, purchase, import, or transfer mags that can hold more than 10 rounds. If the measure is signed into law, it will be considered a classic mag ban, meaning that any further sales or purchases of mags that contain more rounds than the 10-round restriction would be immediately discontinued. Current circulation mags would not be allowed to be sold or transferred, and only those who already owned them would be able to purchase new mags. Current mags would remain lawful. A challenge that arises is the method by which law enforcement would ascertain which arms or mags were possessed before the prohibition was announced. Often, the federal Ghost Safe Act laws, registration processes, and serialization requirements are used to identify arms and mags that have been previously outlawed. There are more proposed arms control measures in New Mexico than only the Ghost Safe Act and the mag ban. There is a push to make the 14-day waiting period for the purchase of arms mandatory. This would be similar to California's 10-day waiting period. Furthermore, there are ongoing attempts to increase the legal age of purchase for arms, to draft language that would circumvent the Protection of Lawful Commerce in Arms Act, PLCAA, and allow anyone to sue arms manufacturers for crimes committed using their products, and to create a red flag statute that would be applicable to the entire state. It seems like New Mexico would likely use wording from a federal bill restricting access to arms, maybe the Armed Crime Prevention and Community Safe Act, which was proposed nationally the year before. This bill contains provisions for age restrictions, purchase permissions, a red flag legislation, an obligatory waiting time, and other measures. The prospect of this word being adopted has sparked concerns about the extent of the arm control measures that may be implemented in the state. It remains to be seen whether the final legislation will include additional provisions beyond those that have been discussed, or if it will be limited to the topics that have been examined. As discussions and bills progress, given the situation, questions have been raised about how the Second Amendment's protection would be affected overall in New Mexico, which might wind up being among the states with the strictest arm control laws.
To a member on the Democratic side that served in a combat area designated zone and deployment of our country.
For years, the Democrats told us we're not coming for your guns. Oh, yes, they are.
I'd also like to address the House on an issue that occurred yesterday in Maine. Another assault weapon.
Urgent concerns in New Mexico. The proposed arm control measures in New Mexico have intensified concerns, primarily due to their expedited introduction during the 30-day legislative session. This session, traditionally focused on budget negotiations and initiatives chosen by the governor, is now being used to fast-track what many perceive as controversial arm control legislation. The urgency and speed with which these bills are being pushed through raise questions about their potential impact on the Second Amendment. The proposed legislation aims to implement a statewide ban on certain rifles and mags, introducing waiting periods, age restriction, and red flag laws. Of particular concern is the potential imposition of mag bans, with the full extent of the legislation not yet fully known. The accelerated timeline for introducing and passing these measures adds an element of urgency to the debate, leaving limited time for thorough consideration and public discourse.
The Second Amendment says the right to keep and bear arms shall not be infringed.
The number of so-called assault rifles, what you all are calling assault rifles, had doubled.
Future of arm control. The future of arm control in the United States is a topic fraught with complexity and intense debate. As the nation grapples with ongoing challenges related to armed violence, legislative efforts to address the issue have become a focal point of political discourse. Several key factors shape the trajectory of arm control policies, influencing the landscape for both proponents and opponents of stricter regulations. One significant factor is the evolving societal attitude toward arm ownership. Public opinion on arm control has fluctuated over the years, often in response to high-profile incidents of mass shootings. Advocacy groups such as Moms Demand Action and Everytown for Armed Safety have been influential in mobilizing support for stricter arm laws. However, a deeply ingrained cultural attachment to arms, reinforced by the Second Amendment of the U.S. Constitution, poses a challenge to the implementation of comprehensive arm control measures. The role of the judiciary, particularly the Supreme Court, is another crucial determinant. Recent decisions, such as those related to state-level attack arms bans, highlight the interpretative disputes over the Second Amendment scope. The composition of the Supreme Court and its stance on individual arm rights versus collective safety considerations will significantly shape the legal framework of future arm control policies. The legislative landscape at both federal and state levels is dynamic, with lawmakers constantly introducing new bills to address armed violence. The success of these initiatives often depends on the political climate, party dynamics, and public sentiment.
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
You say that crime went down, but did you know that the sales of the so-called assault weapons went up?
That's all for this video, folks. See you next time.